ಶ್ರೀಪಾದ್ ಸರ್ ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? ಕೋಟಾಲ್ 12 ಕೋಟಾಲ್ 12 ಶ್ರೀಪಾದ್ ಸರ್. ಸರ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
ಇದೆಯಲ್ಲಿದಮ್ಮ ರಿಮೋಟು? ಹುಡುಕಿ ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ನಮ್ದು ಅಂತ ನಾವು
ಕೋಟಾಲ್ 12 ಶ್ರೀಪಾದ್ ಸರ್ ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? Hotel 12, ಶ್ರೀಪಾದ್ ಸರ್. ಸರ್ LPM ಸರ್. ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? Hotel 12. Kotal 12, ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? ಶ್ರೀಪಾದ್ ಸರ್. Kotal 12 ಇಂದ LPM, sir.
ಕೇಳಿಸಿದಮ್ಮ.
Okay, sir. Video clear ಇದಲ್ಲ sir?
ಕ್ಲಿಯರ್.
ಸರ್ ಮತ್ತೆ ಅದು ಹೆಸರು Xiaomi 210 ಅಂತ ಏನೋ ಬರ್ತಿದೆ, ಅದು ಹೆಸರು ಒಂದು ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ಸರ್?
ಓಕೆ,
ನಿಮ್ಗೆ
ಚೇಂಜ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Serial number 10.
ಹಾ,
It is connected with.
ಒಂದ್ ನಿಮಿಷ ನೋಟ್ ಮಾಡ್ಕೊಂತೀವಿ. ಸಾಹೇಬ್ರದ್ದು ಈ ಕಡೆ ಎಲ್ಲ ಆಯ್ತೇನಪ್ಪ? ಹೇಳಿ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್
10.
ಲಿಸ್ಟ್ ನಂಬರ್ 2, ಸೀರಿಯಲ್ ನಂಬರ್ 10.
ಹೌದು, 3756/19.
3756/19.
ಸೀರಿಯಲ್ ನಂಬರ್ 17.
ಒಂದ್ ನಿಮಿಷ. ಇದು ಸಿಂಗಲ್ DB ಸರ್?
ಸಿಂಗಲ್.
17.
17 ನಲ್ಲಿ 3499/20.
ಇದು ಸಿಂಗಲ್.
ಹೌದು, ಸಿಂಗಲ್.
ಸರಿ ಸರ್.
ಈಗ ಸಪೋಸ್ ನನಗೆ ಆಗದೆ ಇದ್ರೆ ನೀವು ಒಂಚೂರು ಹೇಳ್ಬಿಡ್ತೀರಾ?
ಹೇಳ್ತೀನಿ. ನಂಬರ್ 1 ಫೈಲ್ ಅಲ್ಲೇ ಇದೆ. ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್
ನಾವು ಮಿನಿಟ್
ಇನ್ನೊಂದು ಒಳಗೆ ಇನ್ನೊಂದು ಟಿವಿ ಇರುತ್ತಲ್ಲ ಅದು ಅದು ಇದು ಮಾಡ್ತೀವಿ ಕೊಡ್ತಾರೆ. Next week. Page wise adjournment, list number 2, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 10.
My lord, serial number 10, my lord. It is connected with another matter. I have already informed the court officer.
Yes, call this matter along with.
3756190.
Yes. Page number 3, serial number 11 to 19.
My lord, serial number 17, my lord.
Yes.
It is connected with another matter. I have already informed the court officer.
Call this matter along with this one. Page number 4, serial number 20 to 25.
List number 2, your worship. List number 2, serial number 49, your worship.
Wait. Page number 5, serial number 26 to 28. Page number 6, serial number 29 to 34. Yes. Yes, Satish, at the request of counsel for respondent number 2, release this matter of 2 weeks. Page number 7, serial number 35 to 41.
37, my lord, next week, my lord. Serial number 37.
Yes,
Kindly have it next week, my lord.
at the request of counsel for the appellant, release this matter of 2 weeks. Page number 8, serial number 42 to 48.
Serial number 45, my lord. ಇದರಲ್ಲಿ TCR ಬೇಕಾಗುತ್ತೆ, my lord. I am appearing for the appellant.
Directed to secure original records from the tribunal.
Please, my.
Yes. Yes. You are ready. Then when the matter is reached, we will dispose of. Page number 3, serial number 49 to 57.
Serial number 49, your lordship, ಅದರಲ್ಲಿ TCR ಬರಬೇಕಾಗಿತ್ತು ಸರ್.
49.
Interim order may be extended, your lordship.
What is that interim order?
ಅದರಲ್ಲಿ execution
Then-
ಹಾಕೊಂಡಿದ್ದಾರೆ, stay the operation, judgment
Then
and
you wait.
operation.
Wait, and the matter is called, you can mention. Yes. Yes, what do you want, madam? At the request of counsel for appellant, 2 weeks time is granted. Yes. Kumar. What do you want? You are appearing for? What is your name, Mr.? CS? Yes, at the request of counsel for respondent number 1, release this matter next week.
Serial number 10, yeah.
Yeah. Page number 10, serial number 58 to 63. Page number 11, serial number 64 to 70.
69, my lord, kindly have it next week. Some personal inconvenience today.
At the request of appellant, 2 weeks.
Much obliged.
Yes. Yes. At the request of respondent, 66, 67, 2 weeks. Yes, next week. List number 1, hearing interlocutory application matter, serial number 1 to 11. Please. Admission matter, 12 to 50. Yadas. 5. Issue notice. Office is directed to 6. Admission matter, 12 to 15. Notice. Number 2, for orders. For appellant, Pradeep. Which time is granted to do the needful. Serial number 2, Arini Shivananda.
I appear for the respondent, my lord.
There is
Dispose.
Shyam Prasad. Shyam Prasad, pass out.
I,
Ready? Yes, Sitaram Rao. Pass on. Number 4, Antaraj paper appellant, A. Venkatesh. Venkatesh. Pass on. Number 5, Antaraj paper appellant, MP Shrikant. Yes, where is that? Schedule put in. One third. In all cases, it is 1/3. Yes. Yes. Okay. Notice to R1 and R2 is dispensed. Shantla Learned Council appearing for insurance company has contended that a claim petition is filed under section 163A of the Act as per schedule. As per the second schedule to section 163A, the tribunal has to deduct 1/3 of the income of the deceased for personal expenses. Instead of that, tribunal has deducted 50%. Therefore, the same is contrary to the provisions of 163A of the Act. Hence, he sought for allowing that appeal. Per contra, Shri MP Shrikant Learned Council appearing for insurance company has contended that at the time of the since deceased was a bachelor, therefore tribunal has deducted 50% of the income of the deceased for personal expenses. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. There was judgment and award. It is not in dispute. What is the name of the deceased? Lingappa died in road traffic accident occurred on 10/3/2012. The claimant has filed a claim petition under section 163A of the Motor Vehicles Act. As per that second schedule to that section 163A, the deduction has to be made 1/3 of the income of the deceased for personal expenses. Instead of that, tribunal has deducted 50%. Accordingly, the compensation has been reassessed for 40,000. 23 years 17 22 25 17 ಆ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ 163 ಶೆಡ್ಯೂಲ್ 40 1/3 has to be deducted 40,000 annually 1/3 has to be deducted ಎಷ್ಟಾಯ್ತು into 17. The multiplier applicable to that age group is 17. In addition, 2,000 towards funeral expenses, 2,500 towards loss of estate. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit within 6 weeks. Dispensation allowed. Number 6, Sripadri Shastri for appellant, Y. Aruna.
I am representing Y. Aruna, Your Lordship.
Yes, Shastri. Shastri,
Sir, serial number 6, Sripadri Shastri for appellant, Y. Aruna.
Sir, mic mute
I am
ಆಗಿದೆ.
I am representing Y Aruna, Your Lordship.
Sir, Shastri sir, mic mute ಆಗಿದೆ.
There is a delay of 169 days.
Yes, Mr. Shastri, are you ready?
Yes, yes, my lord, I'm ready, my lord.
Yes, what is that?
It is 4-5, my lord, it's a injury case, my lord.
Yes.
My lord, he was aged 53 years, my lord.
Yes.
My lord, the extent is of the year 2016, that is 12/7/2016, my lord.
Yes.
My lord, he was aged 53 years. My lord, he was
Yes.
working as a seat cover maker, my lord, seat cover maker.
Yes.
Cushion work,
Yes.
cushion work.
Yes, yes.
Sustained fracture of right frontal bone,
Yes.
fracture of roof of orbit, fracture of scapula and ligamental injury.
Yes.
But he was inpatient for 4 days and incurred about 62,000 medical bills. My lord, I have examined 3 witnesses. PW2 and 3 are the doctors. PW2 is the medical to produce medical records, and PW3 is the doctor, neurosurgeon.
Yes.
My lord, the disability is, my lord, he is not able to close his left eye. My lord, there is a severe pain in the shoulder, weakness, memory disturbances. My lord, can't use the right hand and required assistance while walking. And neuropsychological report is also produced.
So what is that doctor's assessed?
40% to whole body. Tribunal is the main head. 50,000 globally ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. It is found in judgment. Well, last ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ page number 15 ಅಲ್ಲಿ last ನೋಡಿ petition entitled
Yes, yes. Yes, yes. Where is the record stand? Will secure the records, Shastri. Yes, because doctor evidence says it is 40%. He has not discussed anything.
How
Yes.
then?
As office is directed to secure, already notice to R1 dispensed. 169 days delay condone, not entitled for the interest for enhanced compensation amount. Office directed to secure original records. Number 7, Vishwanatha K for appellant, O Mahesh. Yes, Vishwanath. Notice to R1 is dispensed. Delay of 155 days condone, not entitled for the interest. Office is directed to secure original records from the public. Number 8, Prakash FC for appellant, Jagadish GS. Yes, Prakash. Password. GS Jagdish Yar. Password. Number 9, Girimalaya for appellant. That who is that other side? ಇನ್ನೊಂದು ಯಾರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪ್ಪಿಲ್ಲ, ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ? ನೋಡಿ ಆ ನಂಬರ್ ಯಾವುದು? Lingraj are. Yes, Lingraj is directed to take notice for respondent number 1. Notice to R2 is dispensed at the risk of the appellant. Week's time is granted to pay the process. Issue notice to respondent number 3. Call this matter along with that so on. United India. You are there, Mr. Nagaraj? Yes. Nagaraj Jaya is directed to take notice. Respondent number 2 is notice to R1 is dispensed. 158 delays condone not entitled for the interest. R2 is served unrepresented. K. Nagaraj Jaya is directed to take notice. Karnataka Council for the appellant is directed to serve one set of copies. Serial number 12, Jagadish entity for appellant Geeta Raj. Counsel for the appellant suggests that he will not press memo for dispensation of notice to R1, hence dismissed as not pressed. Week's time is granted to pay the process issue notice to R1. 13, Jagadish entity for appellant P. Pradeep. Yes. Page number 27. Yes. Disability ಎಷ್ಟಾಗಿದ್ದಾರೆ ಡಾಕ್ಟರ್ ಹೇಳಿದಷ್ಟು ತಗೊಂಡಿದ್ದಾರಾ 20%? ಇನ್ಕಮ್ 12,000 ತಗೊಂಡಿದ್ದಾರಾ? ನೀವೆಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? No. ಫೈನಾನ್ಸ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೊಟ್ಟಿದ್ದಾರೆ. 7% ಕೊಟ್ಟಿದ್ದಾರೆ. ಶ್ರೀ ಜಗದೀಶ್ HT, Karnataka Council appearing for climate has contended that at the time of accident, he was earning 16,000 per month. Tribunal has considered notional income of the claimant as 12,000 per month is on lower side. Other contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, loss of future medical expenses, and other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contrast, if the council appearing for insurance company has contended that even though claimant has claimed that he was earning 16,000 per month, he has not produced any document to establish the same. The circumstances, tribunal has rightly assessed notional income of the claimant as 12,000 per month. Further contended that considering the evidence of doctor and injuries suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that interest awarded by the tribunal is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute claimant has suffered an injury in a road traffic accident occurred on 30th/4/2019 due to rash and negligent driving of driver of the car bearing registration number AA13 N2266. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 7 days. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disabilities 20%. Even though claimant has claimed that he was earning 16,000 per month, he has not produced any document to establish the same. But the circumstances, notional income has to be assessed as per the guidelines for the accident occurring 2019. Notional income has to be considered as 14,000. At the time of accident, he was aged about 22 years. Multiplier applicable to that age group is 18. Accordingly, loss of future income has been reassessed as follows. 20% plus 4,800. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 7 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injuries suffered by the claimant, inclined to enhance the compensation for loss of immunities from 20,000 to 45,000. Loss of income during the later period has to be granted for 3 months. Diet nourishment and appetite. Yes, compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest. Accordingly, appeal is allowed in fact.
I am for appellant, my lord. The respondent present, my lord, I am ready.
Yes. Yes, Mr. Shastri.
My lord, it's a case of injury, my lord. Liability and involvement not in dispute. My lord, only quantum. My lord, the date of accident is 27/1/2019.
Yes.
My lord, he has the age of 30 years, a coolie, my lord, coolie.
Yes.
My lord, claim is 15,000 per month. Tribunal consider 9,000. My lord, sustained fracture of right lower 1/3 tibia and other injuries. He was inpatient for 5 days, my lord, underwent surgery. And open reduction internal fixation was done, and it is still in situ. Required removal, according to doctor, that is a 40%, 40,000 is analyzed by the doctor. But I have examined the doctor and medical record keeper. Total 4 witnesses. Out of that, PW3 doctor evidence is important. Page number 11, para number 16 is important. Whole body disability is 15% as per doctor evidence.
Yes.
8% disability is considered. First ground is pain and suffering, 20,000. Extent is of the year 2019. 20,000 required enhancement for pain and suffering.
Yes. Yes.
Loss of immunities 10,000 is also required enhancement because he is aged only 30 years and able-bodied person suffering 15% whole body disability. Medical, as far as medical expense is concerned, 36,300, which is produced before the tribunal, that has been accepted. Well, the incidental 10,000, it is also seems to be just. Well, loss of earning, only 1 month is considered. 9,000 into 1, only 10,000 is awarded. It required enhancement. Loss of earning for the laid up period. And as far as future loss is concerned, well, 9,000 is considered. Extent is of the year 2019.
Yes.
Disability considered 8%. On these 2 counts, my lord, require interference of my lord.
Yes,
And
what is that disability?
12 15% whole body ಅಂತ ಡಾಕ್ಟರ್ ಅಸೆಸ್ ಮಾಡಿದ್ದಾರೆ, 8% ತಗೊಂಡಿದ್ದಾರೆ. There is no specific reason is assigned. Whole body 15% ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ ಡಾಕ್ಟರ್ ಲಿಂಬ್ ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
ಲಿಂಬ್ ಡಿಸಾಬಿಲಿಟಿ ಹೇಳಿಲ್ಲ ಅವರು. ಟೋಟಲಿ ಹಿ ಅಸೆಸ್ಡ್ 15%. Para 5 of the affidavit says, my lord, only 2 sentences. First, he assessed these squatting, other disabilities, and score is given. Thereafter, my lord, permanent physical, permanent right lower limb 15% ಹೇಳ್ಕೊಂಡು whole bodyನು 15% ಆಗ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. It is left to the court. 15 ರಿಂದ 8 ಮಧ್ಯ ಒಂದು 12% ಹಿಂಗ್ ತಗೊಳ್ಬಹುದು ಅಂತ ಅನಿಸ್ತಾ ಇದೆ, because there is a fracture.
Yes, yes, we will consider.
ಮತ್ತೊಂದು ಹೆಡ್ ಸ್ವಾಮಿ, ಮತ್ತೊಂದು ಹೆಡ್. ಆಮೇಲೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 40,000 ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ, 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ಸಮ್ ಮಾರ್ಜಿನಲ್ ಅಮೌಂಟ್.
No, that where is that? You read. No, you read the entire paragraph. Other petitioner examined so and so produced different exams, disability assessments. Disability assessment they have been evaluated. Fracture ಆಗಿದೆ, but reunited ಆಗಿದೆ ಅಷ್ಟೇ. So fractures are united. But doctor has even that accept setting that wound certificate. No, wound certificate allo ಇದೆ fracture. But considering the above discussion going through that, so on. So. Yes. But Shri Shastri, no council appearing for climate has contended that due to the extent climate has suffered grievous injury, it has undergone surgery. He has examined Dr. Avinash as PW3. In his evidence, he has deposed that climate has suffered 15% disability to whole body. The tribunal has assessed whole body disability is 8% is on lower side. He further contended that at the time of the accident, climate was earning 15,000 per month. Tribunal has considered notional income of the climate as 9,000 per month is on lower side. He further contended that considering that the evidence of doctor and injuries suffered by the climate, the compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Lastly, he has contended that due to the accident, climate has suffered grievous injury. He has undergone surgery. Doctor has deposed that he required 40,000 for removal of implant. The tribunal has granted only 10,000. Hence, he sought for enhancement of compensation. So also learned counsel appearing for insurance company has contended that even though doctor has deposed that the climate has suffered 15% whole body disabilities. In his class examination, he has admitted that fractures are united, wounds are healed, and he was not a treated doctor. Considering that injury suffered by the climate, and considering that evidence of doctor, the tribunal has rightly assessed whole body disability is 8%. Further contended that even though he has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed 9,000 notional income. Further contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, future medical expenses, and other incidental expenses, just and reasonable. Last year submitted that interest awarded by the tribunal 7% is on their side. Hence, he sought for dismissal of topic. Heard the learned counsel for the parties, Pharaoh's judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 27/1/2019 due to rash and negligent driving of driver of car bearing registration number KA53 P2870. Due to that accident, claimant has suffered the following injury. Dr. Avinash Parsharthi has been examined as PW3. In his evidence, he has deposed that claimant has suffered 15% disability to whole body. In his cross-examination, he has admitted that fractures are united, wounds are healed. Considering the same and considering the age and avocation of the claimant, I am of the opinion that whole body disabilities can be assessed 10%. Even though claimant has claimed that was earning 15,000 per month, not produced any document, notional income has to be considered 14,000. At the time of the accident, he was aged about 30. The 34. The multiplier applicable to the age group is 17. Hardly 30 years, huh?
30 years.
30 years, 17, 20.
17 ತಗೊಂಡಿದ್ದಾರೆ.
Yes. $14,000 into 12 into 17 into 10%, 2,85,600. Due to that extent, claimant has suffered the following injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, inclined to enhance the compensation for pain and suffering 20,000 to 40,000. Loss of immunities from 10,000 to 30,000. Loss of income during the later period for 2 months. Due to that accident, claimant has suffered an injury. He has undergone surgery. As per the doctor, he is required 40,000 for medical expenses. Considering that injury suffered by the claimant and considering that evidence of doctor, I am of the opinion that future medical expenses can be enhanced from 10,000 to 25,000. Enhanced compensation amount carries 6% interest. Early in this court. For appellant, Oriental Insurance. Oriental ಯಾರಿದ್ದಾರೆ? Ready? Yes. Notice to R1 dispensed. 11 days delay control. R2 served. Shankar Reddy is directed to take notice. You serve a copy too. Next week, we serve a copy. Vishwanatha Pujari K for appellant. K. Srinivasa. Notice to R1 dispensed. Yes. Number 17 adjourned. Number 18. Sripad Vishal 3 for appellant. Then Keshav Prashant. For the respondents case, please.
My lord, I am for appellant, my lord. It's a case of, my lord, it is 6241.
Serial number 18.
Yes, my lord, I am for appellant, my lord.
Yes.
My lord, a 17 years boy, my lord, is a sustained
Yes.
fracture of, my lord, the date of accident is 11/2/2019.
Yes.
He was aged 17 years, studying in first year PUC. My
Yes.
lord, sustained fracture of left femur and fracture of right styloid and facial injuries, my lord. And there is a severe bleeding also. My lord, he was treated in private hospital for 7 days. My lord, I have examined the doctor, my lord, PW2, PW3, the medical record keeper. According to Dr. Mellad, he underwent a surgery for fixation of steel rods. And the subsisting disability is 18% to whole body. That is 55% to left lower limb, 18% to whole body. Medical bills produced 1,75,732. That has been accepted, Mellad. I have no grievance on that.
Yes.
Mellad, tribunal, by following the Mallikarjun case, Mellad,
Yes.
by adding 3 lakhs towards other head and 50,000 towards the loss of earning and future medical expense 25,000. Well, totally 5,51,000 is awarded. My respectful submission is, since I was aged 17 years and about to earn, getting majority, well, the compensation under different head, well, is required to be assessed by considering the notional income and adopting the multiplier and also considering the 18% whole body disability. Well, if it is reassessed, well, I will get some more compensation, not too much hiking. It is already. Well, is a set. ಕೇಳ್ತಾ ಇಲ್ಲ ವಾಯ್ಸ್.
Yes.
Whether I'm heard properly.
Yes.
Well, my respectful submission is, since he is aged 17 years, well, the Mallikarjun case is not applicable, and if the compensation is reassessed on various permissible heads, well, I get some more compensation. Already 5,51,000 is awarded. Well, instead of granting 30,000 and 50,000 towards the loss of earning, well, if under multiplier method, well, 18% disability is considered, and by adopting the multiplier of 18, and by considering the notional income of 14,000 to 2019 accident, well, I'll grant some.
Yes, Mr. Keshav Prashant.
ನಾನು ಮುಗಿಸ್ಬಿಡ್ಲಿ ಸುಮ್ಮನೆ ಅವ್ರು ಏನ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದಾರೆ ಅಂತ ಗೊತ್ತಾರೆ.
ಅಲ್ಲ. Whether it has to be assessed under that Master Mallikarjun or as in general this thing.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಟೂಡೆಂಟ್ ಮಿಲಾಡ್ ನಾನ್ ಅರ್ನಿಂಗ್ ಪರ್ಸನ್. Applying the Malad, the Mallikarjun case is also not appears to be correct, Malad, but we cannot consider this chart also. Having regard to the Malad, the age and the student, non-earning person. So nominal like our calculation ಏನು ಹೇಳ್ತಾ ಇದ್ರು. So once at least ಮಾಡ್ಬಿಟ್ರೆ ನಾನು ಆಮೇಲೆ I will come into the.
ಅಷ್ಟೇ ಅದೇ ಪಾಯಿಂಟ್ ಫಸ್ಟ್.
ಅಲ್ಲ ಅವ್ರದೊಂಚೂರು ಕ್ಯಾಲ್ಕುಲೇಷನ್
2,44,000 ರೂಪಾಯಿ ನನಗೆ ಹೆಚ್ಚು ಬರ್ತದೆ. ಅಂದ್ರೆ ಆಫ್ಟರ್ ಡಿಡಕ್ಟಿಂಗ್ 3 lakhs, 2,44,000 ಆ ಹೆಡ್ ಮೇಲೆ ಬರ್ತದೆ. ಈ 50,000 ಹೋಗ್ತದೆ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್, ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್, ಲಾಸ್ ಆಫ್ ಇಮ್ಯುನಿಟೀಸ್, ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್.
No, that one of them has produced some judgment on that point. I will consider that. Yes, next week.
ಆಗ್ಬೋದು. ರೀಸನಬಲ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್.
ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ರು ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ನಾವೇನ್ ಅದ್ರ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ನಮ್ದು ಇಬ್ಬರಿಗೂ ಯಾವ್ದು.
No, he is not agreed for that.
ಅಲ್ಲ, ಈ ಚಾರ್ಟ್ ತಗೊಳ್ಳೋದು ಬೇಡ, ನಾಮಿನಲ್ ಆಗಿ ಇನ್ಕಮ್ ತಗೊಂಡ್ ಮಾಡೋದಕ್ಕೆ ನಂದೇನು ಇಶ್ಯೂಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಬಟ್
What is the nominal income?
ಅಲ್ಲ,
What is that
2019 ಆಕ್ಸಿಡೆಂಟ್ So 14,000 rupees, my lord, as per the income fixed by the Karnataka Legal Service Authority. So that is appears to be on higher side, my lord. Having regard to the, my lord, he was a student. Kelsa Martha, I was definitely would have not, my lord, raised this issue. So nominal minimum income may be considered and reasonable enhancement may be granted. I have no issues on that.
Yes,
I will
Mr.
not say that
Shastri.
my lord, Mallikarjun case is in play, because up to 15 years.
ಅಲ್ಲ, ಈಗ ನನಗೆ I can't go against these principles because my lord, the
Yes, we'll see.
income that
You produce some judgment on that the persons who have suffered. Students.
Now decide ಮಾಡಿ
ನನ್ನ ಹತ್ರ-
ತಗೊಳ್ಳೋಣ ಅಂತ ಅಂದೇನು issues ಏನಿಲ್ಲ.
No, that since he is in a 17 years,
ಹೌದು.
another 1 year he may start earning.
ಸ್ಟೂಡೆಂಟ್ 10th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಸ್ಟೂಡೆಂಟ್ ಅಂತ ಅವರೇ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ತಾರೆ.
ಹೌದು ಅಲ್ಲ ನಾನು ಅಲ್ಲ.
ಹಂಗಾಗಿ
In addition to that, he may do some
ಡಿಗ್ರಿ ಏನೋ ಇದ್ದಿದ್ರೆ ಡೆಫಿನೆಟ್ ಆಗಿ ನಾನು ವುಡ್ ಹ್ಯಾವ್ ನಾಟ್ ಅಬ್ಜೆಕ್ಟೆಡ್.
But these subsisting disability is permanent in nature. That is why throughout his life, my lord, that is why this multiplier method applicable ಅಂತ ನಾ ಹೇಳ್ತೇನೆ.
I will take that
ಮೆಥಡ್ ಅಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ನಂದೇನು
ನಿಲ್ಲಿ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್?
income. Will take that 10,000.
10,000 ತಗೊಂಡ್ರೆ ಅಷ್ಟೇ ಬರ್ಬೋದು. 10,000
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ನೋ ಇಶ್ಯೂಸ್. ಐ ಹ್ಯಾವ್ ನೋ ಇಶ್ಯೂಸ್.
ನೋಡಿ ಸ್ವಾಮಿ, ಒಂದ್ಸಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಈಗ ಹೇಳ್ಬಿಡ್ತೇನೆ. 10,800 ಇಂಟು 12 ಇಂಟು 18 ಮಾಡಿದ್ರೆ ಒಂದ್ ಸೆಕೆಂಡ್, 1,800 into 12 into 18, it comes to 3,88,000 means 88,000 ರೂಪಾಯಿ ಅಷ್ಟೇ ಜಾಸ್ತಿ ಬರ್ತದೆ. ನಂಗೆ 2,44,000 ರೂಪಾಯಿ ಬರ್ತದೆ. ಆದ್ರಿಂದ ಇನ್ನು ಬಿಟ್ವೀನ್ ಆದ್ರೂ ಮಾಡಿ 10,000 ಯಾಕಂದ್ರೆ ಇದೆ
11,000. Yes, 11,000 will. Yes, sir.
ಆಗ್ಬೋದು ಸರ್, ಮುಗಿಸ್ಬೋದು. ಐ ಹ್ಯಾವ್ ನೋ ಇಶ್ಯೂಸ್.
Yes. Three. Shastri, Learned Council appearing for insurance company as claimant has contended that at the time of the accident, claimant was aged about 17 years and he was studying in first PUC. He has suffered grievous injury in this accident. The tribunal has error in relying on the judgment of apex court in case of Mallikarjun, where that in that case the Supreme Court has considered the injury suffered by the children. Here he was aged about 17 years. Therefore, the loss of future earning has been assessed by the tribunal is
loss of future
lawyer inside.
ಕೊಟ್ಟಿಲ್ಲ. ಅದು 3 lakh rupees ಮಿಲಾಡ್ as a
3 lakhs rupees assessed by the tribunal for disabilities is on lawyer side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient. Yes, din hospital alidru.
He was inpatient for 7 days, man. 7 days. Underwent surgery also.
Yes. He has suffered a lot of pain during the treatment. The overall compensation awarded by the tribunal is on lawyer side. Hence, he sought for enhancement of compensation. For contra, Shri Keshav Prashant, Learned Council appearing for insurance company, has contended that at the time of the accident, claimant was aged about 17 years. He is a student studying in first PUC. Since he was non-earning member, tribunal has right.
On the date of action, he was studying 10th standard. So at the time of evidence, my lord, when the evidence is given, so his father has said that my lord, he was studying in.
Yes, he was studying 10th standard, and he was non-earning member. Tribunal has rightly considered the judgment of apex court and granted a just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. Perose judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 11/2/2019 due to rash and negligent driving of driver of bus bearing registration number KA 50 A3874. At the time of the accident, he was aged about 17 years. He was a student. Considering his age and considering that evidence of PW1, I am of the opinion that the monthly income of the claimant can be assessed as 11,000 per month. Doctor has rightly assessed whole body disabilities 18%. The multiplier applicable to the age group is
Tribunal-
also 18.
Tribunal considered 15%, madam. Doctor said 18%. Tribunal or 15% ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಾರೆ.
Where is that?
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಮೇಲೆ
18%.
ಡಾಕ್ಟರ್ ಹೇಳಿರೋದು 18%. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 14 ಮೇಲೆ 24 ಮೇಲೆ.
Yes.
24.
Considering that evidence of doctor and injuries suffered by the claimant, I am of the opinion the whole body disabilities can be assessed 18%. The multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows. 18%, 4,27,680. The medical expenses. In addition, the claimant is entitled 20,000 for
40,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್. ಡಾಕ್ಟರ್ ಫಾರ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ರಿಕ್ವೈರ್ಡ್ ಒನ್ ಮೋರ್ ಸರ್ಜರಿ ಅಂತ.
No. All that will be considered. You will not consider separate. You will give 20,000 for pain and suffering, 20,000 for future medical expense. Then it will cover all head.
20,000 ಸ್ವಲ್ಪ ಕಡಿಮೆ ಆಗ್ತದನೋ ಕಾಣ್ತದೆ. ಯಾಕಂದ್ರೆ ಒಂದು ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಫೀಮರ್ ಇದೆ.
We are not assessing as a general this thing. Just on consent of both the parties, you have decided.
ಹೌದು, ಎರಡು ಫ್ರಾಕ್ಚರ್ ಇದ್ದದಕ್ಕ ಕೇಶವ್ ಪ್ರಶಾಂತ್ ಎಷ್ಟು ಹೇಳ್ತಾರೋ
ಇಲ್ಲ,
ಅಲ್ಲ ಅವ್ರು ಎರಡು ಫ್ರಾಕ್ಚರ್ ಇದ್ದದಕ್ಕ ನಾಳೆ ಆಯ್ತು ಸ್ವಾಮಿ.
He was student, non-earning member, studying 10th standard. Only question whether it is applicable for that Master Mallikarjun or other things. Then both have agreed for 11,000. Now you can't ask in all head, mister. Then you will ask for a marriage prospects also. It is not under that.
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದೇನೆ. I have to stick on to that.
Medical expenses awarded by the tribunal has been retained. Loss of income during that hospital period income 50,000 awarded by the tribunal as retained. Future medical expenses ಕೊಟ್ಟಿದಾರಲ್ಲ 25,000
ಕೊಟ್ಟಿದ್ದಾರೆ.
25,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. 40,000.
Yes, that is retained. In addition, 20,000 rupees for pain and suffering.
Amenities.
And 20,000 rupees for loss of amenities.
Much better.
Yes, accordingly, the appeal is allowed in part. Judgment and award possible. Yes.
Much of
I am for appellant, my lord.
Yes. Yes.
My lord, the case of injury. My
Yes.
lord, accident is of the year 2018. My
Yes.
lord, he has aged 37 years.
Yes.
Working in a quarry as a writer anta ಹೇಳ್ತಾನೆ.
Yes.
No documents or other materials is produced. 18,000 anta he has deposed.
Yes.
He sustained dislocation of right shoulder associated with fracture of great tuberosity. So one the dislocation and one fracture. He was inpatient only one day in Mysore hospital.
Yes.
My lord, according to Dr. PW4, my lord, there's a 10% whole body disability. There are medical bills 6,707 rupees produced, my lord, that has been accepted. My lord, the compensation towards pain and suffering 10,000 and the loss of amenities, including other expense incidental ಅಂತ 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. In both the heads, my lord, page number 15, paragraph number 25 onwards is the ಮತ್ತೊಂದು ಕೇಸ್ ಇದೆ ಪೇಜ್ ನಂಬರ್ 15 ಪ್ಯಾರಾ ನಂಬರ್ 25.
Yes.
Pain and suffering amenities 17,000 each. Amenities ಅಲ್ಲಿ it includes incidental ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
ಆಮೇಲೆ medical expenses 6,700 bills produced that has been accepted. Attendance charges ಅಂತ 5,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of earning only 2,000 awarded.
This is 4269.
4269 page number 15 onwards. Para number 25.
Yes. Pain and suffering 10,000. Nutrition, food and amenities 10,000. Loss of income during the treatment period. Attendance charges. Future income 61,000. Yes, Shastri. Now you said it.
4% ತಗೊಂಡಿದ್ದಾರೆ 10% ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ 8,500 ತಗೊಂಡಿದ್ದಾರೆ.
What is the limb disability assessed by the doctor?
ಅದು ಟೋಟಲ್ ಬಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು 10% ಅಂತ ಅಂದಾಗ ಆ ಕೋರ್ಟ್ ಬೈ ಡಿಸ್ಬಿಲೀವಿಂಗ್ ದ ಸೇಮ್ 4% ತಗೊಂಡಿದ್ದಾರೆ. It is left to the court. It is left to the court.
Yes. Yes. Whole body. ಯಾರು ಇದು?
PW4 ಮೇಲೆ ಡಾಕ್ಟರ್ PW3 Armugam. PW
Avinash Parsharthi. 4. PW4. Yes, he is giving in all cases evidence like this one.
ಹೌದು ಅವರು ಅದೇ ಹೇಳ್ತಾರೆ ಅದೇ ಅಸೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಹಂಗೆ ನಿಮ್ ಜುಡಿಷಿಯರಿಲಿ ಇರ್ಬಹುದು. ಅವ್ರ ಹತ್ರ ಐ ಹ್ಯಾವ್ ಪರ್ಸನಲಿ ಕಾಂಟ್ಯಾಕ್ಟೆಡ್ ಹಿಮ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಹೇಮ್. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನೀವು ಫ್ಯೂಚರ್ ಲಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದ್ರ 1/3 ಮಾಡ್ಕೊಳ್ಳಿ. ನಮ್ಗೆ ಹಂಗೆ ಬರೋದಿಲ್ಲ.
What is that injuries? Orthopedic.
Anterior dislocation of right shoulder.
Yes, as per that medical guidelines, they can assess each part of the body. Then he has to say this is that permanent disability. Then we can say that this is whole body. He cannot say both is whole body. See, 35% disability. 35% disability to one leg adre, if you compare to whole body, cannot be a 35.
ಹೌದು.
Maybe depending upon that avocation and all, it may be vary, but it cannot be same percentage.
ಹೌದು. ಆ ಟೆಲಿಸ್ಕೋಪಿಕ್ ಫಾರ್ಮುಲಾ ಉಪಯೋಗಿಸಿದಾಗ
Yes. No surgery. Where is that?
ಸರ್ಜರಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಡಿಸ್ಲೊಕೇಶನ್ ಆದಾಗ ಕನ್ಸರ್ವೇಟಿವ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗ್ತದೆ.
Yes.
ಈ ಡಿಸ್ಲೊಕೇಶನ್ ಟು ಸಮ್ ಮೆಡಿಕಲ್ ಒಪಿನಿಯನ್ ಇಟ್ ಈಸ್ ವೆರಿ ಡೇಂಜರಸ್. ದಟ್ ಟು ಶೋಲ್ಡರ್ ಮೇಲೆ ಪದೇ ಡಿಸ್ಲೊಕೇಶನ್ ಆಗ್ಬಿಡ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ಜೋತಾಡ್ಲಿಕ್ಕೆ ಶುರು ಆಗ್ಬಿಡ್ತದೆ ಹೇಳುವಂತ ಒಂದು ಒಪಿನಿಯನ್ ಮೆಡಿಕಲ್ ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಇದೆ.
Yes, 9% interest ಇಟ್ಟಿದ್ದಾರಾ?
ಹೌದು 9% ಸ್ವಾಮಿ 9%.
Yes, ಹೇಳಿ. Shastri, council appearing for the claimant has contended that at the time of the accident he was earning 18,000 per month. Tribunal has assessed notional income 8,500 is on lower side. Further contended that doctor has assessed whole body disability is 10%. Tribunal has considered 4% is on lower side. Further contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 1 day. He has suffered lot of pain during the treatment. Compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence he sought for enhancement of compensation. For contra, Krishna Kishore Learned Council appearing for the claimant, the insurance company has contended that as per the evidence of doctor, the permanent physical disability has been assessed 10%. Therefore, tribunal has rightly assessed that whole body disability is 4%. Further contended that even though he has claimed 18,000, he has not produced any document. Lastly, he has contended that considering that injury and evidence of doctor, and he has not undergone any surgery as admitted by the doctor, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses just and reasonable. Lastly, he has contended that interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 5/5/2018 due to rash and negligent driving of driver of tanker registration number KA19 C2553. Due to that accident, he has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disability is 4%. Even though he has claimed that he was earning 18,000 per month, he has not produced any document. As per the chart for the accident occurring in 2018, 12,500 has to be considered. He was aged about 37 years. Multiplier is 15. Accordingly, loss of future income has been reassessed as well. Due to that extent, claimant has suffered following injury. The opposite injury was inpatient for a period of 1 day. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered to the claimant, try to enhance the compensation. Pain and suffering from 10,000 to 40,000. Loss of nutrition, food and amenities from 10,000 to 35,000. Loss of income during the later period for 1 month. Attendance conveniences has to be enhanced from 5,000 to 8,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6%.
The loss of earning for the later period is ಕೊಟ್ಟಿರೋ ಗೊತ್ತಾಗಿಲ್ಲ.
1 month.
1 month.
Ramya Niru, B. Pradeep, M. Venkatesh, KSRTC. Ready? Why that KSRTC is third unrepresented? You are there.
Respond number 9.
50-50 ಇದ್ರ ಮೇಲೆ. ಯಾವ್ದು No, that one you are appearing for which insurance? Who is appearing for? M. Venkatesh is there. Yes. Venkatesh. New case artist. ನಿಮ್ಮ ಮೇಲೆ ಎಷ್ಟು percent? ನಿಮ್ದು? Which insurance company? Pradeep is appearing for which insurance? Sriram. Sriram general is 50. Yes. Nobody has challenged the filing in appeal. Yes. Yes, Mr. $39. 2018. Page number 34 LI3. Yes. Disability dispute ಇದೆಯಾ? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಕರೆಕ್ಟ್. ಇನ್ಕಮ್ ಎಷ್ಟು ಕ್ಲೈಮ್? Yes. What would be that 2018? 12,500. ಎಷ್ಟು ದಿನ ಆಯ್ತು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ? Loss of future earning, pain and suffering. ಎಷ್ಟು ಇಂಜುರಿ ಇದೆಯಪ್ಪ? Yes. Sickness and traveling, loss of later period, nourishment, attendance charges, amenities ಕೊಟ್ಟಿಲ್ವಾ? ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿಲ್ಲ? Yes, Mr. Darshal. Yes, Mr. Venkatesh.
The papers, I requested him in the morning to give me a set of papers so that I can prepare and argue the matter. Still, in spite of it, application dispensation, now he is arguing the matter.
Yes, you serve a copy. Huh? Oh, that no, after service.
ಅವರೇ ಫೋನ್ ಮಾಡಿದ್ರು ನನಗೆ.
ಏನಂತ?
ನಾನು ಏನ್ ಮಾಡ್ತೀವಿ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಲ್ಲಪ್ಪ, ಒಂದು ಕಾಪಿ ಕೊಡು, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡೋಣ ಅಂದೆ.
Yes, we serve a copy. Yes. Notice so and so is dispensed. Yes. Ramya and ಮಾಡಿದಾರ? Yes, Ramya and Hiryu is has filed an wakalat for R2. Also, office is directed to show his name for R.
For opponent, Tata AIG.
B. Pradeep, notice to R1 dispensed. 279 days delay condone not entitled for the interest. R2 served unrepresented. B. Pradeep is directed.
Number 22, Raghu R for opponent, Shankar Reddy, United India.
Yes, Shankar Reddy. Shankar Reddy is R4. Shankar Reddy. 2017. ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? ಹಾ 2017 12,000. Then deduction ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲ 1/4 ಕೊಟ್ಟಿದ್ದಾರಾ? 1/4 40% ಆಡ್ ಮಾಡಿದಾರಾ? 40% has to be added. Who are the claimants? ಅವರಿಗೆಲ್ಲ ಎಲ್ಲರೂ they are entitled for 44%. Yes, 11,000 disposed of.
Number 23, Raghu R for opponent, B. Pradeep.
Yes. ಇನ್ಕಮ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ತಗೊಂಡಿದಾರಲ್ಲ, ಬೇರೆ ಇದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಒನ್ ಥರ್ಡ್ ಕರೆಕ್ಟ್ ಇದೆಯಾ? ಅದ್ ಬಿಟ್ರೆ ಸ್ಪ್ಲಿಟ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇಟ್ ಇಸ್ ಕಮ್ ಲೇಟರ್, ಇಸ್ ಇಟ್ ನಾಟ್? ಫಸ್ಟ್ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಎಷ್ಟು ಅಸಸ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಇನ್ಕಮ್ 10,000 ಅದು ತಗೊಂಡಿದ್ದಾರೆ. ವಾಟ್ ಈಸ್ ದಟ್ ದಿ ಏಜ್? 55 years. 10% has to be added. Is a employee 15%. Then what is the deduction? Wife and major sons, are they depending upon him? 1/3. 1/3 deduction. 1/3 deduction. 10,000? Or 15 income. Multi 10% addition. 15% addition. What is that age? 11 multiplier ಹಾಕಿದಾರ ಟ್ರಿಬ್ಯುನಲ್ ಬಿಡಿ 11 is that this thing 11 ಗೆ ಸ್ಪ್ಲಿಟ್ ಮಾಡಿರೋದು ತಾನೆ 11 ತಗೊಂಡಿದ್ದಾರೆ 11 ತಗೊಂಡಿದ್ದಾರೆ ಅದರ್ ರೇಟ್ಸ್ ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ ಎಸ್ ಅದರ್ ರೇಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಸ್ಪ್ಲಿಟ್ ಮಾಡಿ from ground ಹಾಕೊಳ್ಳಿ tribunal is error in adopting split multiplier for calculating loss of dependency. Apex court in case of so and so. In view of the judgment of apex court so and so, loss of dependency has been reassessed as follows.
Number 24, Raghuwar for a friend. Yes, Jagdish.
Yes, Mr. Jagdish. Notice to R2 is dispensed. 91 days delay in filing this control. ಎಲ್ಲಿದೆ 2000 as per the team 14,500. ಇದು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದಾರಾ ಎಷ್ಟು ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಕೊಟ್ಟಿದಾರಾ ಇಲ್ಲ ಹೇಳ್ರಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇಸ್ ನಾಟ್ ಆಡೆಡ್ ವಾಟ್ ಇಸ್ ದ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 34 years 40% ಆಮೇಲೆ ಕರೆಕ್ಟ್ ಆಗಿದೆ 1/4. then who are the claimants? All are entitled. Yes, interest another difference idea 6% ಇದೆ. That's all. Income ಮಾತ್ರ 14,500. Yes, plus 40%. Yes, Mr. Wife and 50% ಮಾಡಿದಾರಾ ಅಷ್ಟಾದ್ರೊಂದೇ ಇನ್ಕಮ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ all is correct. Only 1/3 has to be done. Yes, only instead of 50, it has to be 1/3. Company appeal idea. ಹೌದಾ interest has to be reduced to 6%. Entire. Yes. Amount in deposit is transferred to the tribunal. Reassess ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. Delay is condoned. Yes. Dispensation allowed. Yes.
Serial number 26. Arjani Desai for appellant.
Non-compliance of office objection. 2 weeks time is granted.
Interlocutory application matter. Serial number 27. Om Mahesh for appellant. A.K. Bhatt.
Pass or where is my? Or we'll have it on Tuesday. Pass or Mahesh is not there. Pass or yes.
Number 28. Shantaraj K for appellant. H.C. Bettor.
Yes. Ready? Hmm. Additional affidavit hakidra? Why you have moved then? Yes, mister. If you are you have not seriously objected, I will condone that delay. No interest. Yes, sir. What is that other head? Then we'll secure the records. Where is that? Which? Yes, from which tribunal? Tumkur. Office is directed to secure original records from the tribunal. Forthwith, post immediately after. There is a delay of 2657 days in filing an appeal. Oh, if you are seriously disputing, I will ask him to file an affidavit. Then I will pass the order. That's what you have to say, my mister. You are disputing that. Yes, you file an affidavit, additional affidavit. Yes. Call for records.
Number 29.
Yes. Delay of 20 days condoned. Heard, admit. Let the records come.
Number 30.
Anyhow, that dismissal matter, even this court or other court, they will say that admitted. Instead of that, better now it will be admitted. Yes.
Serial number 30. Jagadish Agati for appellant. K. Suresh.
I prefer the respondent.
Yes.
Our submission scale style or something. Our submission scale style. Mic use mara.
Yes. Where is that finding? Yes. Read.
But he was not having license to drive the passenger car and carry stated in order to ID. The driver must possess the motor cab license. Thus, from the is a vehicle is a commercial vehicle, it was not holding not. Yes, I think the motor cab license along with that is the evidence of clearly indicated the driver was not fully however, the carbon is not being identified because there is no mention in the traffic. It does not mean that the content of the traffic and absolutely this is in the case we will give the indicate that the road was not
Yes. Yes. Yeah. 50. Date of accident? 14. ನಿಮ್ದು ಇನ್ಕಮ್ ಎಷ್ಟು ಅಂತ ಕ್ಲೈಮ್ ಮಾಡಿ ನೀವ್ ಎಷ್ಟು ಹೇಳಿದ್ರಿ? What is your claim? Huh? $25% ಕೊಟ್ಟಲ್ಲ 10% ಆಡ್ ಮಾಡಿದಾರಲ್ಲ 25%. ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? 1/3 ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಓನ್ಲಿ ಇನ್ಕಮ್. Yes, Mr. Suresh.
Yes, idರಲ್ಲಿ as the driving license did not hold the transport endorsement, the petition is dismissed against the insurance company, my lord. In this month, this Mukunda Devangan case has been referred to the larger bench in Ramba Devi case, my lord. Therefore, await the orders of the larger bench antane adjourn ಮಾಡಬೇಕು sir.
No. Have you read that judgment?
Yes,
when it is referred.
House.
When it is referred, they have admitted that till disposal will follow the judgment of Mukund Devagan. That is that at the time of reference, that is an order. All insurance company has admitted that will follow that judgment of Mukund Devagan till disposal.
My submission may be noted, my lord.
Yes. That's all. ಅದೆಲ್ಲ ಕೊಡಿ ರೆಫರೆನ್ಸ್ ಮುಖಂಡ.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದೇನು ಹೇಳಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲ ರಂಭಾದೇವಿ ಕೇಸ್ ನಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು.
In para 5 of the Rambhadevi's judgment,
yes.
In para 5 of the Rambhadevi's judgment, it is very clear, having bestowed our attention to the contentions raised by the learned council and the issues which fall for consideration.
ಆಯ್ತ್ರಿ, para 8 ಓದ್ರಿ.
Rambhadevi case, Swami.
From
at the request of the learned council, these matters are de-tagged anta hakidare Swami.
Para 8.
Para 8 ಅಲ್ಲಿ ಏನು ಅಷ್ಟೇ ಸುಮ್ಮನೆ ಆಗಿರೋದು. Para 8 ನಲ್ಲಿ at the request of the learned council these matters are detailed ಅಂತ ಇದೆ.
That is para 9.
ಅಲ್ಲ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ರಂಭಾದೇವಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ Para 8 ಲಾಸ್ಟ್ ಸುಮ್ಮನೆ.
No, I have a judgment. Para 10 is there.
This is
Para 8.
This is dated 8 March 2022. Bajaj Alliance General versus Rambadevi.
Yes. Yes, 8 March 2022.
Awesome.
Para 8. Before we part, we must note that all the learned counsel appearing for the insurance company have fairly submitted that compensation in terms of directions issued by the court below. That is to say, in the following principle, down in the Mukund Devgan has either been paid in full or shall be paid in terms of sub directions. The statements are recorded.
Right.
Then para 9, at the request learned counsel, the matter at D-tag. List this matter on 9/3/2022. This is that order.
Yes, ma'am. Yes, ma'am. My submission may be noted.
Yes. So and so learned counsel appearing for the claimant has contended that at the time of the accident, he was aged about 50 years. The tribunal has assessed notional income of the claimant as 7,000 per month is on lower side. Contended that even as per that notional income fixed by Legal Service Authority for the accident occurred in 2014 is 8,500. Further contended that in view of judgment of Apex Court in case of Magma, the claimants are entitled 40,000 each. Hence is 44,000 each. Hence is sought for enhancement of compensation. In respect of liability, he has contended that even though as on the date of the accident, driver of the offending vehicle as holding license to drive LME non-transport, but he was driving the transport vehicle. In view of judgment of Apex Court in case of Mukund Devgan, the insurance company is liable to pay that compensation. Hence, he sought for allowing that appeal. Per contra, Suresh learned counsel appearing for insurance company has contended that even though that at the time of the accident, deceased was aged about 50 years. Considering his age and avocation, tribunal has rightly assessed personal income of the claimant as 7,000 per month. Other contended that considering his age and avocation of the deceased, overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 9% is an higher side. In respect of liability, he has contended that judgment of Apex Court in case of Mukund Devgan has been referred to larger one. In case of Bajaj Alliance General Insurance Company Limited, Ramba Devi and others. Hence, he contended that since insured has violated the policy condition, the tribunal has rightly exonerated that insurance company. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. Lingappa died in road traffic accident occurred on 5/4/2014 due to rash and negligent driving of driver of car bearing registration number KA2 AA978. At the time of the accident, he was aged about 50 years. As per the guidelines issued by Karnataka Legal Service Authority, personal income has to be considered for the accident occurred in 2014. 8,500 has been considered as monthly income of the deceased. Tribunal has rightly deducted 1/4 of the income of the deceased for personal expenses and added 25% for future prospects. Multiplier has been considered multiplier. Tribunal has rightly considered that multiplier as 13. Accordingly, loss of future earning dependency has been reassessed as follows.
8,500 plus 2,125 at the rate of 25%, 10,625 minus 2,656 at the rate of 1/4, 7,969, 7,969 into 12 into 13, 12,43,164.
In addition, claimants are entitled 16,500 for loss of estate, 16,500 for criminal expenses. In view of judgment of export in magma, first claimant is entitled 40,000 Pillai Consortium. 3 and Yellaru Makla 2 to 4 are entitled 44,000 each for parental consortium. In respect of liabilities is concerned, it is not in dispute as on the date of the accident. Driver of offending vehicle was holding a driving license to drive vehicle with gear and LME non-transport, but he was driving that transport vehicle. Since in view of the apex court in case of Mukund Devagan has held that driver holding a LME license can drive all vehicles of classes, including transport vehicle, if unladen weight of the offending vehicle doesn't exceeding 7,500 kg. In the case in hand, the unladen weight of offending vehicle is less than 7,500 kg. In view of that above judgment, the driver of the offending vehicle was having valid and effective driving license. The insurance company is liable to pay the compensation. The apex court in Ramadevi and other Supra, as while referring, has recorded the statement of the learned counsel for the insurance company. The same is extracted below, para 8 extracted. In view of the above, the insurance company is directed to deposit entire compensation amount with interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is
and recover the same from insured. Recover the same from the insured.
Ad baralri Mukund Devagan case recovery barala.
Tomorrow, if it is very difficult to,
that is not that
larger bench reverse adre.
That is not that concern of the court. As on this day, what is the law is there that has to be applied. We cannot presume what is happening in that. No, you show me that any judgment on that point. Yes. That will not survive for consideration. Which is that 30, serial number 30. Yes. In view of disposal of the appeal, all pending applications has been disposed of. Delay as condoned, not entitled for the interest for a period of 363 days.
Serial number 31 adjourned. Serial number 32 Nagesh M for opponent, SBI Mulpur.
146 days delay condoned. Yes. Prakashbeka. Next week.
33, Renuka for appellant, Mohan Bhatt.
Appear for the appellant, my lord.
Yes.
My lord,
Yes, what is the?
my lord, exhibit P8 may kindly be seen, my lord. The negligence is challenged in this case. The LCR is before the court, my lord.
Yes, LCR has come. We will have it on Tuesday. We'll hear
Lord,
that main matter.
Can it be after vacation? Next Thursday, Martin.
Next Thursday or January first week. First week of January. Yes.
Number 34, M. Venkatesh for appellant, B.S. Sachin.
Court has already directed 50% to be released in favor of the claimants. ಮತ್ತೆ ಹಾಕೊಂಡು ಯಾತಕ್ಕೆ ಬಂದಿದೆ ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ.
ಏನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಅಮೌಂಟ್ ಏನು?
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ. ಯಾವಾಗ ಡೇಟ್ ಆಗಿದೆ
ಅಲ್ರಿ ನಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ರಿ?
ರಿಲೀಸ್ 12 lakhs ಅಂತ ಆಗಿದೆ. 50%.
Registry is directed to release 50% ಆಗಿದೆಯಲ್ಲ, ಇಲ್ಲಿ ರಿಲೀಸ್
ಆಗಿದೆ.
ಎಲ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಐತಲ್ರಿ? ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ಇದಲ್ರಿ ಈ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿದೆ. ಅಯ್ಯೋ 1/21. ಅಲ್ರಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಡೈರೆಕ್ಷನ್ ಡಿಸ್ಕೋ ಟು ರಿಲೀಸ್ ಆರ್ಡರ್ ಹಾಗೆ ಇದೆ, ಇನ್ನೇನಂತೆ?
28/3/21 ಆಗಿದೆ.
ಅದರಲ್ಲಿ 50% ನಮ್ಮ ಡೆಪಾಸಿಟ್.
ಯಾಕೆ ಇಲ್ಲೇ ತಗೊಂಡ್ರೆ ಏನಾಗುತ್ತೆ? ಅಲ್ರಿ ಈ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕ್ರಿ? ದೇರ್ ಇಸ್ ಆಲ್ರೆಡಿ ಎನ್ ಡೈರೆಕ್ಷನ್ ಆನ್ ಫಾರ್ ದಟ್. ಇದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಯು ವಿತ್ಡ್ರಾ ಹಿಯರ್. ಕ್ಲಿಯರ್ ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ರಿ. ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ರಿಲೀಸ್. ಮತ್ತೆ ವೈ ಡು ವಾಂಟ್ ಒನ್ ಮೋರ್ ಆರ್ಡರ್? Why then what about this order, mister? ಸುಮ್ಮನೆ ಒಂದು ಆರ್ಡರ್ ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಏನ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ, ಅದು ಆರ್ಡರ್ ಬೆಲೆ ಇಲ್ವಾ ಹಂಗಾರೆ? Either it has to be recalled, is it not? As for your direction only, this court has clearly directed registry is directed to release 50% of that amount. Now he has filed that, transfer that. What about this order then? Why can't you withdraw here? Yes. There is this matter after 2 weeks. Yes, learned counsel for the appellant. Alla, respondent, ಯಾವುದು serial number? Respondent submits that he will not press IA 1-2 of 2022. Hence dismissed as not pressed.
Number 35, stating appellant H.S. Lingaraj, P.N. Nanjareddy.
For 9/2018. 72. Yes, sir. 2018 on. Per day ಅಂತ ಅಂದ್ರೆ 15,000. You have claimed 15,000. ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? 50% ಮಾಡಿದಾರಾ? Yes. There is no dispute on that. Only conventional act. Huh? No. Why? 50% is not disputed. Income has to be enhanced. And other head has to. ಅವರು 15,000 ಕೇಳಿದ್ದಾರೆ. 500 ರೂಪಾಯಿ ಪರ್ ಡೇ ಆದ್ರೆ ಎಷ್ಟಾಯ್ತು ಮಂತ್ಲಿ? ಅದನ್ನೇ ಹೇಳಿದ್ದು. Who are you? Yes. Liability is fixed on the insurance company or the owner? Insurance company. It was 9%. Where's delay of 227 days. Not entitled for the interest. 227 days delay condone. Not entitled for the interest. Magala, limit. Yes. Tribunal has granted compensation. You have not challenged. ಮಗಳಿಗೆ ಎಲ್ಲಿದ್ರು ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಕೊಡ್ಲೇಬೇಕಾ? 44%. That is cannot be denied. Loss of estate, funeral expense cannot be denied. Dependency has been assessed by the tribunal, you have not challenged. Only thing is income you have to be reassessed. Yes, right. Don't show. Learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 500 per day. Tribunal has assessed notional income of the deceased as 8,000 per day per month is on lower side. He further contended that in view of judgment of apex court in case of Megma, the claimants are entitled 44% each. Hence, he sought for enhancement of compensation. Per contra, Sri L. Lingraj, learned counsel appearing for insurance company, P.N. Nanjareddy appearing for the owner has contended that even though claimant has claimed that he was earning 50,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the deceased as 8,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, they contended that interest awarded by the tribunal 9% is on higher side. Hence, they sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. What is the name of the deceased, Mr. Narsamma? Died in road traffic accident occurred on 4/9/2018 due to rash and negligent driving of driver of the car bearing registration number AP03 BW9599. Even though claimant has claimed that deceased was earning 500 per day, they have not produced any document to establish the same. Under other circumstances, notional income has to be assessed as per the guidelines for the accident occurring in 2018. Notional income has to be considered as 12,500. Tribunal has rightly deducted 50% of the income of the deceased for personal expenses. The multiplier applicable to the age group is 5 on 5. Accordingly, loss of dependency has been reassessed as follows.
500 minus 6,250, rate of 50%, 6,250. 6,250 into 12 into 5, 3,75,000.
Addition 16,500 loss of estate, 16,500 criminal expenses. The claimant is entitled 44,000 for parental consortium. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is disposed of. Not entitled for the interest for a period of 227.
For respondent, my lord.
Ready, Mr. Ashok?
It's only in respect of here income has been taken as 8,000 for the accident of 2018. 1,500 can be.
What is the date of that?
1/2/2018.
ಎಷ್ಟು income claim ಮಾಡಿರೋದು? 25,000. 10,000 ತಂದಿದ್ದಾರೆ. 2018 12,500. ಕೊಟ್ಟಿದ್ದಾರೆ. 45 years. Second.
Really, second respondent is major. Sorry, second petition.
Where is the finding of the tribunal?
Page number 12. Number 12, 21, page number 12.
12 or?
Para number 12.
Okay.
Para number 21.
Then where is that evidence? What is? Who is PW1? He himself has been examined. Pratap. Where is that statement? That has spent towards I submitted deceased Sidramaya was well and healthy. 20,000. So I submitted the dead body of the father. Wife aging over 40 years, myself, two our sons and daughters. My father deceased was a good state of Yes, Mr. He himself has given a evidence. Nothing has been elicited. He said that he is depending upon the income of the father. Just because major, you cannot deny. Unless it is prove that he has his own separate income. But he himself is a witness. Yes. 1/3 Madidara.
He has not produced any document regarding that. I mean, he is a student. He should be telling at least he is a student that he is studying that.
No. He himself has appeared before that. He said that I am depending upon the income of my father. In cross-examination, you have not elicited saying that no, you have your own income or he is doing any business. Nothing. 20 years or young matter. Yes. Astana? Interest? Yes. 3. Raghu or learned counsel appearing for.
As far as age is concerned, my lord, they have not produced any document. Only on the basis of the post-mortem report, age has been considered. In fact, they have produced all other documents, that is Aadhaar of all others, but Aadhaar of the deceased they have not produced. Please, if they have produced, tribunal has taken post-mortem report as evidence. When they have produced the Aadhaar of all the claimants, why they have not produced the Aadhaar of the deceased? What prevented them from producing the same?
No, nothing prevented you to challenge that finding of the tribunal. You have not challenged that. You have accepted. Is it not? It's a facts given by the finding given by the tribunal. Cannot be reversed without appeal. Insurance company na athwa KSRTC?
Yes, sir.
Yes, Thali. Sri Raghu, learned counsel appearing for. Claimant has contended that at the time of the accident, claimant was earning 25,000 per month. Tribunal has assessed personal income 10,000 is on lower side. Further contended that claimants are entirely depending upon the income of the deceased. The tribunal has, instead of, there are 4 claimants, they are entirely depending upon the income of the deceased. The tribunal, instead of deducting 1/4 of the income of the deceased for personal expenses, has deducted only 1/3. He further contended that in view of judgment of apex court in case of Megma, claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. Per contra, The Ashok Kumar Learned Counsel appearing for corporation has contended that even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed personal income is 10,000 per month. He further contended that claimant number 2 is the son of the deceased, is a major. He is not depending upon the income of the deceased. Therefore, tribunal has rightly assessed 1/3 of the income of the deceased for personal expenses.
He was 23-year-old when the accident took place. This second, as per
Yes.
Aadhaar.
Yes, he was a major, yes. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Sitaramaya died in road traffic accident Takada 1/2/2018 due to rash and negligent driving of driver of KSRTC bus registration KA6F816. Even though deceased claimant has claimed that deceased was earning 25,000 per month, they have not produced any document to establish the same. The circumstances. The notional income assessed has to be assessed as per the guidelines. For the accident occurring 2018, 12,500 has to be considered. There are 4 claimants. The claimant number 2, who is the son of the deceased, was a major. He has been examined as PW1. In his evidence, he has categorically stated that all the claimants are entirely depending upon the income of the deceased. As examination of PW1, respondent has not elicited any worthwhile information. Therefore, there are 4 dependents in view of judgment of apex court in case of Sarala Verma. 1/4 of the income of the deceased has to be deducted for personal expenses. Future prospects kottidara?
Kottidare.
Yes, tribunal has rightly added 25% of the income of the deceased for future prospects. The multiplier applicable to that age group is 14. Accordingly, loss of dependent
3,500 plus 3,125 at the rate of 25%, 15,625 minus 3,906 at the rate of 1/4, 11,719, 11,719 into 12 into 14, 19 lakhs 68,792.
addition 16,500 loss of estate, 3,500 funeral expenses. Payment number 1, 40,000, 44,000, total 2, 3 parental, 4 final.
Delay has to be
Not entitled for the interest.
much obliged.
330 days. Yes.
Serial number 37 adjourned. Serial number 38, D. Latif for appellant.
For the appellant, there's a delay. Notice has to go.
38, 37.
Notice has to go, my lord. There's a delay
Yes,
of
yes.
172 days.
37 are thoroughly connected. 38 notice.
Where?
Number 39, Sushmita G. for appellant. J. Vishwanatha, then Krishna Kishore.
Which one? Number. Call this matter along with that sound. Office is directed to secure original records.
Number 40, Jagadish Shetty for appellant.
ಹೌದು. 50% each. ಆಯ್ತು 50% ಡಿಪಾಸಿಟ್ ಮಾಡಿ. Yes, heard. Yeah. Also subject to deposit 50% of that award amount. Notice.
Serial number 41, N. Venkatesh for appellant, connected matter, K. Satish Chandra.
Furnishing of ಯಾರಿಗಪ್ಪ?
Sir, in 41, my lord, I take notice for United India served antiದೆ.
Yes.
Therefore,
Directed to take notice for respondent number 3. Yes.
Yep.
ಆಟೋಗೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಎಮೋ ಎಲ್ಲ ಐತ್ರಿ? ಫೈಲ್ ಇನ್ ದಟ್ ಆಫೀಸ್. Yes.
Prakash Image for appellant, K. Pradeep.
Yes, next week for the request of.
Number 43, Raghu R for appellant, Janardhan Reddy.
Suresh.
Yes, ma'am. Yes, ma'am.
Ready, Suresh?
Yes, madam.
Delete the name of Janardhan Reddy. ಓನರ್ ಮೇಲೆ ಆಗಿದೆಯಾ? ಓನರ್ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ ಫೈಂಡಿಂಗ್?
Number 18 is page number 22 of the judgment, number 18.
23 ಓದಿ.
Number 24 last.
23 ಓದಿ. Para 23.
Taking into consideration of law laid on the journal of cannot even direct the legislature to pay the economic compulsion in the instant as it does. That's the power. And although the 124 are minute upon the decision, but however, the law has not been seen have been laid on investing the tribunals to directly pay the pay and then they recover the power amount. And this second response is totally approved.
Where is that discussion? Tara, what is the facts in this case? What is the fact? Alri, driving license, facts. Number
15. Page number 15 of the judgment. For the investing of 181 of against the driver of the vehicle. The second response has also got agreement one of this order was rejected together non-possession of the valid and effective driving license by the driver of the correspondent vehicle. And although the correspondent has been duly served and otherwise provide the service of advocate who has right of patient to remain innocent, but however retired from the case on 21 to 2007. Movement at rate of master before the court that the fact driver of the vehicle was arresting the valid and been totally unmindful to the aspect of the matter and therefore taking into consideration it could be directly concluded that the driver into vehicle was not possessing valid driver finding them include answer the point number 2 in the
Yes, what about the quantum?
45 years. 43 years. Page number 19 of the judgment after dependency in the 18 of the judgment.
Yes.
43 years at the time of the accident.
3 years. Date of accident?
Date of accident 33 2017.
25%.
25% damage.
What is that?
9,500 pounds.
17 years then. 11,000.
Wife and daughter. Wife and son.
Correct ಇದೆ. Interest?
Age is deceased age 46 years Swami, as per the Aadhaar card. 46 ವರ್ಷ ಇದೆ.
ಕ್ರಿಮಿನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರಪ್ಪ?
43 ತಗೊಂಡಿದ್ದಾರೆ.
43 ಮಲ್ಟಿಪ್ಲೇಯರ್ ಎಷ್ಟು?
46 ಗೆ 13 ಆಗುತ್ತೆ ಸ್ವಾಮಿ. 13.
No, tribunal has taken 43.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಅವರ ಆಧಾರ್ ಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಇಯರ್ ಆಫ್ ಬರ್ತ್
No.
71.
That finding of the fact, have you challenged? You have accepted that order of the tribunal.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ನಮ್ಮ ಮೇಲೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ ಅವಕಾಶ ಇರಲಿಲ್ಲ.
Finding you can challenge. Who said that?
ಬಟ್
Appeal, any finding can be challenged by filing an appeal.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವರ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ವಾಮಿ, ಆಧಾರ್ ಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರುತ್ತೆ. ದೇರ್ ಡಾಕ್ಯುಮೆಂಟ್
Where is that?
ಎಕ್ಸಿಬಿಟ್ P9 ಅಂತ ಕಾಣ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ 3 ಆಧಾರ್ ಕಾರ್ಡ್ ಹಾಕಿದ್ದಾರೆ. ಡಿಸೀಸ್ಡ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲೂ ಸಹಿತ 1971 ಅಂತ ಅವ್ರ ಇಯರ್ ಆಫ್ ಬರ್ತ್ ತೋರಿಸುತ್ತೆ ಸ್ವಾಮಿ.
1971.
ಹೌದು ಸ್ವಾಮಿ.
What is the date?
He is age 46 years at the time of death.
17 years. What is the date of the accident?
2033 2017 sir.
One 1975. Was it?
46 years, 2 months, 29 days.
Yes, Mr. Multiplier. Yes. What else, Mr. Suresh?
And the rider of the motorbike did not have a valid and effective driving license on. Therefore, the company has tribunal has held that company is not liable to pay the compensation and exonerated the company from paying the compensation.
Pay and recovery.
I see.
Raghu, Learned Council appearing for climate has contended that at the time of the accident, deceased was earning 20,000 per month. Tribunal has assessed notional income 9,500 is on lower side. Other contended that In view of judgment of apex court in case of Magma, claimants are entitled 44,000 each. Lastly, he has contended that the tribunal has given a finding. The driver of the offending vehicle was not having valid and effective driving license. Insurance company has been exonerated from the liability. However, offending vehicle is covered with valid insurance policy. Third parties is concerned. Insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. Support of his contention, he has relied on judgment of apex court, Popu and Swansing, and full bench of this court. Which is sought for contra, disgraced learned counsel appearing for insurance company has contended that even though it has claimed that he was earning 80,000 per month, he has not produced any document to establish the same. About tribunal has rightly assessed notional income 9,500. Contended that as per that Aadhaar card produced by the claimant, deceased was aged about 46 years. Tribunal has error in held that he was aged about 43 years. Further contended that considering that age and avocation of the deceased, overall compensation awarded by the tribunal is just and reasonable. Respect of liability has contended that since insured has violated the policy condition, tribunal has rightly exonerated the insurance company, which is sought for dismissal of the appeal. Heard the learned counsel for the parties. Rose, judgment and award. Yaar Nagarajuna. Who is that?
This is Nagaraj.
Nagaraju died. Road traffic accident occurred on 30/3/2017 due to rash and negligent driving of motorbike bearing registration number AA06 EF 8260. Even though claimant has claimed that deceased was earning 20,000, not produced any document, notional income has to be considered 1,000 per month. Tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses and added 25% for future prospects. As for that Aadhaar card exhibit, study certificate and Aadhaar card exhibit P9. The date of birth of the deceased was 1970. The date of year of the deceased is 1971. According to that, as on the date of the accident, he is aged about 46 years. The multiplier applicable to that age group is 39. Accordingly, loss of tendency has been reassessed as well.
7,000 plus 2,750, rate of 25%, 13,750 minus 4,583 at the rate of 1/3, 9,167. 9,167 into 12 into 13, 14 lakhs 30,052.
Patient 16,500 loss of estate, 16,500 for rental expenses. In view of judgment of apex court in case of, when I said first claimant wife 44,000, second 44,000. The tribunal has given a finding that driver of the offending vehicle was not having valid and effective driving license. The insured has violated the policy condition. and exonerated that insurance company from the liability. However, in respect of third parties is concerned, in view of judgment of apex court in case of Poppu, Swansing and full bench of this court, insurance company has to pay that compensation amount at first instance, liberty to recover from the owner of the offending vehicle. Accordingly, the appeal is allowed in part. Insurance company is directed to deposit with liberty to recover from the owner of the offending vehicle. 44. Ready? Just delete the name of Janardhan Reddy for R1.
Yes, in case of injury, rate of 4.8. Right next to humor. Inpatient, needed. Time of the accident, the nurse engineer. The monthly income and 40,843. After disability,
40,840 yen. What was he? The loss of future earning Kotila. Okay. Guest income ತಂದಿದ್ದಾರೆ 8,000 ತಂದಿದ್ದಾರೆ. By 8,000.
After assisted disability, 59% lower. 90% lower.
Correct. ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್?
59% lower. 19%.
ಸರಿ ಆಯ್ತಲ್ಲ ಅಲ್ಲಿ.
Time ಕೊಡ್ತಾರೆ only 15.
1345.
If replacement
ಇನ್ಕಮ್ ಎಷ್ಟು ಬರುತ್ತೆ ನೋಷನಲ್ 2016 but you have not good then you will secure the records. You'll see that office is directed to secure original records from the treatment.
Let it be Jwala Kumar.
For the first respondent.
Yes. Is there any dispute regarding liability?
Yes, they are disputing.
Yeah. Then we'll secure the records. Bandida, we'll have it next week. Yes, we'll use this next week.
Kumara Chamber Apparent, Janardhan Reddy.
No dispute.
The accident is of year 2018. I will consider only 7,500 as an income.
ಎಷ್ಟು ಕೇಳಿದ್ರಿ?
45,000. Working as an electrician and life to be earning 25,000.
12,500.
So 4 members are lifelines of wife and children. 1/4 has to be deducted.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
ಮಾಡಿದ್ದಾರೆ 1/4 ತಗೊಂಡು. So rightly taken 10% to the perspective considering the age of 51 years. As far as the consortium is concerned, only 80,000 has been awarded, additional 80,000 has been.
Yes, that's all. Interest?
So 9% to the
6%. 2018. Liability is 25,000. 7,500. As for the chat, 12,500. Other they are correct. 10% future prospects. In terms of that magma, 6% interest. Yes. Entitled for the interest for a period of 186 days.
Kapoor for appellant, D. Vijay Kumar.
Where is your next week? Your opponent is not there. Next week. Yes.
Till number 48, 49 adjourned. Till number 50, Satish Akin for appellant, Reliance General Insurance.
Reliance ಯಾರಿದ್ದೀರಾ? You are there, madam. You are there, Reliance. Huh?
Serial number 49, Your Lordship.
Yes.
Serial number 49, Your Lordship, interim order may be extended, Your Lordship.
49 ಏನಾಯ್ತು? 49 ಅರ್ಜನ್ ಆಗಿಲ್ರಿ ಬೆಳಗ್ಗೆ. ಅಲ್ರಿ ಬೆಳಗ್ಗೆ ಅರ್ಜನ್ ಆಗಿಲ್ರಿ. When that matter is called, you submit ಅಂತ interim order extension ಹೇಳಿ. Pass over 230.
Your Lordship, kindly, because I have another matter, Your Lordship.
Yes, you proceed. We have to see what is that interim order, madam. File has sent by mistake. I heard interim order extension is mentioned in that.
Your Lordship, the execution has filed in the other court. Judgment and award has been.
Who are you?
I'm for the claimant. I'm for the corporation, Your Lordship. It's a corporation appeal, Your Lordship.
KSRTC.
Yes, Your Lordship.
What is that interim order granted by this court?
In the MUC case, interim order passed the judgment and award, Your Lordship.
No, what is the interim order? Tell me, what is that interim order?
The order, Your Lordship. Operation of the
Yes.
judgment and award of the MUC case, Your Lordship.
Is it limited or until further orders?
Is limited, Your Lordship. Next, till the next date of hearing, Your Lordship.
Then yes, interim order granted earlier is extended till next date of hearing. Or admit.
Much obliged.
Satish Akin for appellant, Reliance General Insurance.
Reliance ಯಾರು ಹೇಳಿದ್ರಲ್ಲ? Ashok and Patil is directed to take notice. Yes, learned counsel for the appellant is directed to serve one set of facts.
Till number 51 adjourned. Till number 52, Raghu R for appellant, B. Pradeep.
Ready? Yes.
Yes. Total fracture of both was of fibulate mallet, fracture of ankle and other injuries. 36%
Income. Claim ಎಷ್ಟು?
Claim mallet 50,000 doing fully work.
Yes. 14 days in patient.
14 days in patient.
ಎಷ್ಟೆಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Parents of the nurse or amenities future medical expenses loss of income during treatment period.
Yes, that's all. Also, learned counsel appearing for. It has contended that at the time of the accident, he was earning 15,000 per month. Tribunal has considered notional income of the claimants as 7,500 is on higher side. Other contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 14 days. The compensation awarded the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri B. Pradeep, learned counsel appearing for insurance company, has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,500. Other contended that considering that injury suffered by the claimant, considering that evidence of doctor, overall compensation awarded to the tribunal is just and reasonable. It is sought for dismissal of topic. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 18/4/2017 due to rash and negligent driving of driver of truck trailer bearing registration number KA44 T7798. Due to that extent, he suffered following injury. Tribunal has rightly assessed whole body disabilities 12%. Even though he has claimed that he was earning 15,000, has not produced any document. As per the chart, notional income has to be considered as 11,000. The time of the accident, he was aged about 54 years. Multiplier is 11. Accordingly, loss of future earning has been reassessed. Due to that extent, claimant has suffered following injury. Was inpatient for a period of 14 days. For a lot of pain during the treatment. He has to suffer this disability and inconvenience throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I'm of the opinion, I'm inclined to enhance the compensation for pain and suffering from 10,000 to 40,000. The loss of immunity is 10,000 to 30,000. Loss of income during the later period for 3 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Granted earlier, further period of 2 weeks until that. Entry further date of hearing ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಳಿಸಿದ್ರೆ
Number 53 adjourned, cell number 54, GM Srinivasa Reddy for appellant, DS Krishna, Manjula and Tejasvi.
next week. Next Wednesday.
Sanar Kumar came for appellant.
Yara? Yes. Auto served and presented B. Pradeep is directed to take notice.
Card along with the 2.88.
Yes, call this matter.
Number 56, Mahadeva Swami P for appellant, Srinivasa KM, Nathan Reddy.
Where is Srinivas? Yes, next week he is not there. Yes, none appear for R1. Office is directed to delete the name of Janardhan Reddy. Yes, none appear for R1 next week. Bharat next week.
Sayed Abdul Sabur for apparent, Radha BP.
Where is your opponent? Next week. None appear for respondent. This is next week. Records beka.
Number 58, Ananda KS for apparent, BB Shivanegoda.
Income ಎಷ್ಟು ಲೈವ್ ಮಾಡಿರೋದು ಅವರೇ ಎಷ್ಟು ಲೈವ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಎಷ್ಟು ತಾಂಡಿದೆ ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟಿದೆ ಅದ ಎಷ್ಟು ಅಂತ 15%. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಎಷ್ಟು ಇಂಜರಿ ಇದೆ ಮಿಸ್ಟರ್ ಸುಮ್ ಎಮ್ಯುನಿಟಿ ಸರ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟರ್ ಪೀರಿಯಡ್ 3 months ಕೊಟ್ಟಿದ್ದಾರಾ ಎಸ್ what is that interest 6%. Sri Anand KS Learned Council appearing for climate has contended that for earning 20,000 per month, Kunal has assessed notional income as 9,000 is on lower side. Further contended that due to the tax time, climate has suffered previous injury, was inpatient for a period of 19 days. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. He sought for enhancement of compensation. For contra, Shivanegoda Learned Council appearing for insurance company contended that even though climate has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 9,000 per month. But contended that, considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 13/6/2019 due to rash and negligent driving of rider of Honda bearing registration number AA05 JC 1481. Due to the accident, claimant has suffered following injury. Tribunal has rightly assessed whole body disabilities 15%. Even though he has claimed that he was earning 20,000 per month, not produced any document. Personal income has to be considered as 14,000. At the time of the accident, he was aged about 30 years. The multiplier applicable is 16. What is that age? 33 years. 33 years. 16, 33. 16. Accordingly, loss of future earning has been reassessed as. To that extent, claimant has suffered the following injury. Inpatient for a period of 19 days. Suffered a lot of pain during the treatment. He suffered a lot of. He has to suffer the disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, it enhanced compensation, pain and agony from 20,000 to 40,000. Loss of amenities from 10,000 to 25,000. Loss of income during the later period for 3 months. Compensation awarded by the tribunal other hand, just and reasonable. Hence disposed. Yes. ECR has to be called. Yes, office is directed to secure original records from the tribunal.
VP Siddaramaiah for appellant, Ravi Samprati, Radha BP.
Ready? No. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇನಾ? So learned counsel appearing for the claimant has contended that in view of judgment of apex court in case of Pranay Sethi, the claimants are entitled 16,500 for loss of estate, 16,500 for criminal expenses, and in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence, is sought for enhancement of compensation. For contra, Shri Ravi Samprati, learned counsel appearing for insurance company, has contended that considering the age and avocation of the deceased, the tribunal has granted a just and reasonable compensation. Heard the learned counsel for the parties. There was judgment and award. It's not in dispute. What is the name of the deceased, Mr. Virupaksha? Died in road traffic accident on 10/10/2019 due to rash and negligent driving of. ಯಾವುದು KSRTC ಬಸ್? Yes. For you are appearing for the KSRTC also. Liability ಯಾರ ಮೇಲೆ ಇದೆ? ಹಾಗಾಗಿ yes. Yes. Due to rash and negligent driving of driver of KSRTC. ಅದರಲ್ಲಿ Ravi Samprati, and you have filed an wakalat, madam. Number estido? Yes. R1 Ravi Samprati and Radha BP submits that. Due to rash and negligent driving of driver of bus bearing registration number KA01 F9048. Tribunal has, after considering the evidence of parties, has rightly granted a compensation for loss of dependency. Compensation awarded by the tribunal on the head of loss of dependency is just and reasonable. In view of judgment of apex court in case of Pranay Sethi, the claimants are entitled 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, yaru first claimant? For the second mother, the claimants 1 and 2 are entitled 44,000 each for filial consortium. To that extent, judgment and award is modified. The insurance company is directed to deposit enhanced compensation amount with 6%. Yes, madam.
Serial number 49, Lalita PM for appellant.
Interim order has expired in 2021. You said next date of hearing.
Lordship,
Where is that
I
interim order?
I have noted
Where
in
is
my
that?
diary.
Where is that?
My application, Your Lordship.
Yes. Then 10:30 you are mentioning extension of interim order. This is how that means. Yes. Until further interim order illa. Yes. All this matter next week.
Call for LCR. Your Lordship.
Yes. Call for LCR. Start with next week. Beda. Call this. Call that. Records. Office is directed to call for record system.
Serial number 61, M. Venkatesh for appellant.
Sir, I am for claimant.
I am for the appellant, my lord.
Yes, Mr. Venkatesh.
My lord, the liability fixed on insurance company is questioned in this appeal. The question for consideration is whether death is in the course of and arising out of employment due to stress and strain. He was a car driver for a lawyer. Car driver for a lawyer. And in the morning they were going to temple. He has traveled about 4 or 5 kilometers. And he died due to cardiac arrest and tuberculosis. Exhibit P8. You will actually kindly see the PM report. PM report. Tuberculosis in the yellow barala, yellow helala. And it is not in the court. Right? Because of stress and strain, it comes under everything.
No, Mr. Last occasion he has relied on judgment. Have you gone through that?
But not there. I have gone through that judgment. There, nothing is connected with this case. That judgment is not related to this judgment.
Why?
No way it is not applicable.
Why?
Why that is not discussed here. Only 2001 page, 2007 page 1. The Supreme Court has discussed doctors should be examined to prove that he is dead out of stress and strain of the employment.
No, doctor has been examined. But whether it is no.
In this case, doctor is not examined.
No, that is for deciding whether this is a substantial question of law or not. That is the issue.
That it is a substantial question of law. That is what 2007 page 1 says. It is substantial.
Yes, where is that?
What is the name?
2007?
Reported judgment code.
2007?
2007 ACJ page 1. There it is said doctor should be examined. Medical evidence is a necessity.
Recently, one more judgment, Justice Sandesh.
Yes.
He died after that accident. That we have the copy. Yes. That which is that 2007 judgment.
Shakuntala Chandrakant Seshti.
Shakuntala Chandrakant Seshti versus Prabhakaran.
Yes, we will have it on Monday. Yes, Monday.
Yes, madam.
Yes.
Madam, can you have it? Kindly have it on Tuesday, madam.
Tuesday. You furnish that judgment.
Yes, madam. I furnish it.
Tuesday. Yes. 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 None of your use this matter. 2 weeks.
Gurdeva Prasad for appellant. Ravi Shankar.
Yes, ready. Sapi. On what ground? Huh? Yes. Where is that finding? Para 10. Yes.
Specific case of the therefore it is relation not the current relationship. This regard, the not only one who has closed on behalf of the two company, because the driver of the restaurant Larry, that is Rajesh, son of Purna Malayan, are not registering Larry here. In this regard, the restaurant company itself has made a complaint because the paid and before the district company of saying that the restaurant number two company has failed to provide sufficient service and failed to indemnify the driver. In this regard, the restaurants have produced and considered the hardcore, the judgment copy and complaint. The said judgment has been discussed by the district complaint as in the date of the driver of the restaurant market possessing the pay. The details are discharged in the day of the
It is, they have proved by discharging their liability. Only thing is pay and recovery. ಮಾಡಬಹುದಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಓನರ್ ಅಪೀಲ್ ಅಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡಿದ್ದಾರೆ ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಬಹುದಂತ ಮಾಡಿದ್ದಾರೆ. This is the question has been raised. Supreme Court judgment consider ಮಾಡಿ Justice Sanjay Gowda has held that even in owner case also pay and recovery. That is recent judgment. That's what that judgment I have to follow. Yes. Yes. Damage to the lorry. For that he will support because pay and recovery. That is now there is a judgment. Gallery. Sanjay Gowda judgment. See, no. Question of law has been framed and it has discussed and has held. Unless I will consider. Yes, I will consider. Yes. What is that for this thing? Quantum.
The compensation has been awarded only on the basis of serious report.
No evidence.
Here has been examined.
I do not accept the New York concept. Photographs produced by the petitioner, PW2 petitioner has proved that he has incurred not less than 97 due to the repair and said lorry. As per the report produced by the surveyor, petitioner has paid the survey fee 2018, so and so. As such, all the petitioner is entitled damages of 97,000 plus 3,000 towards the survey fee. What is the documents they have produced? But they have not produced that this thing. Repairs bills has not produced. ಅಲ್ಲ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ ಏನೋ ಇದೆಯಲ್ಲ ಏನದು ವಾಟ್ ಇಸ್ ದಟ್ ವೈ Now that first we'll see how that accident is occurred.
Two lines are involved. Two lines are involved. This is 7 to 7 and with the only
7 to 7. Now the damage is 3 to 79. ಅಲ್ಲ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ ಹೋಗಿದೆ. ನಿಮ್ದು ನೀವು direct consumer phone. Yes. Who is appearing for the owner? Served under. Alala, climates. Climates of that means owner of that lorry. Other lorry. Who is that owner of other lorry? Ade petitioner in the claim petition. Served unrepresented, alva? Yes. Now that, has he produced any bills? Alala, any bills has been produced? What is records? Lot of income during the repair period.
Means you are already Maya. It record also. It will be 6 to 23 photos and negatives.
Survey report ಕೊಟ್ಮೇಲೆ ರಿಪೇರಿ ಮಾಡಿಸಿದಾರೋ ಇಲ್ಲ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ. So what is this exhibit P24? ಅಲ್ಲ, the vehicle particulars ಅದು. Private and confidential motor final survey report. Oh, it's a survey report. Professional fee, covering charges. Yes. Yes, that's all. ಇವ್ರದ್ದು ಕೊಡಿ. Which is that paragraph? Whether final and binding on the parties held, obtaining such a report is a prerequisite for a settlement of the claim or more, but report is not a final and binding on the parties. Para 21 and 22.
Namely, 22.
Para?
In other words, although the assessment of loss by the approved surveyor, that is
Para 9.
22. Look at 22.
Which paragraph?
22 paragraph.
22. In the other words, although assessment of the loss by the approved surveyor is prerequisite to the settlement.
But surveyors is not the loss.
Not the perfect number. It is not a conclusion. The approved survey report may be insurance company, sovereign company, but such report is neither binding upon. Yes. ಅಲ್ಲಿಗೆ 20,000 plus 3,000, 23,760. Yes. ಅದು ಇದೇನ್ರಿ ಸಂಜೆ ಗೊತ್ತಿತ್ತು. ರಿಪೋರ್ಟ್ ಸಿಕ್ಕಿಲ್ಲ, ಆಗಿಲ್ಲ. No, that is, you are appear in that case before Sanjay Gowda, that award of the compensation, it has advanced insurance review petition. Whether the driver of the vehicle didn't pass the valid authority. Insurance and recovery cannot be applied if the owner has entered appearance or owner has preferred an appeal. Nimde appeal. Gurudev Prasad avara idare. The question, the insurance company submitted principle of pay and recovery cannot be applied if the owner has entered in appearance or owner has preferred an appeal. The contention sought by the advance is that principle of pay and recovery will have to be applied only when there is not contested by the insured or so on. So in view of arguments, basically so on. The length of the said principle argument, if the owner has entered an appearance, the principle of pay and recovery will not be applied, cannot be advanced at all. Owner of the vehicle appear at contested liability so on. Yes. See, Uday Prasad Learned Counsel appearing for the insurance company, the claim owner of the offending vehicle has contended that the driver of the offending vehicle, contended that the insurance company has not discharged their liability by proving the driver of the offending vehicle was not having valid and effective driving license. Since they have failed to discharge their liability, the tribunal is held that insurance company is not liable to pay that compensation. In respect of quantum, he has contended that the claimant, except producing survey report to claim that he has suffered loss of 97,000 rupees, he has not produced any repair bill. Therefore, he contended that survey bill itself is not a final. Not a final and binding on the parties. In support of his contention, he has relied on judgment of Apex Court in case of Pradeep Kumar versus New India Insurance Company Limited, 2009 7 SEC 787. It is sought for allowing that appeal. Per contra, P. Ravi Shankar Learned Counsel appearing for insurance company has contended that the insurance company has examined its employer and it has proved they have discharged their liability and proved that driver of the offending vehicle was not having valid and effective driving license. And tribunal has rightly exonerated that insurance company. In respect of quantum, he has contended that he has supported that argument of Learned Counsel for the appellant. The claimant has served unrepresented. Heard the Learned Counsel for the parties. Whereas judgment and award is not in dispute. The petitioner is the owner of the lorry bearing registration number KA05 AA3279. Is also not in the dispute. Said lorry has suffered any damage in a road traffic accident occurred on 19/12/2007 due to rash and negligent driving of driver of lorry bearing registration number KA04 A0727. The petitioner has filed a claim petition under 166 of Motor Vehicles Act seeking damages caused to that said lorry. Except producing exhibit P25 survey report to show that he has incurred 97,000. Exhibit 24, he has incurred loss of 97,000 rupees. He has not produced any repair bill or any spare parts he has purchased. only on the basis of that estimation, the tribunal has granted a compensation of rupees 90,000, 97,000. The same is contrary to material available on record. Apex Court in case of Pradeep Kumar Supra has held that paragraph 22 extract. In view of the above, that since the claimant has not produced any repairs bill or he has not produced any bill related to the spare parts he has purchased, the compensation awarded by the tribunal under the head loss of repairs of the said lorry 97,000 rupees is unsustainable. In respect of compensation awarded by the tribunal for survey fee and loss of income during the repair period has to be maintained. In respect of liabilities is concerned, the insurance company has examined this employer as RW1. Yes, because other name but yes. Yes. Since they have discharged their liability, they have discharged their the insurance company has discharged their liability and proved that driver of the offending vehicle was not having valid and effective driving license. Since the total compensation is awarded 23,765 with interest. The driver of the appellant has already deposited that amount before this court. The same may be transferred to the tribunal. Accordingly, they have discharged. They have proved that driver of the offending vehicle is not having valid and effective driving license. Hence, tribunal has justified in directing that appellant to pay that compensation amount. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The driver of the offending vehicle, appellant is directed to deposit that compensation amount with interest. Amount in deposit is transferred to the tribunal. If there is any balance, is directed to be deposited by the appellant. ಅದಕ್ಕೋಸ್ಕರ ಬೇಡ ಅಂತ 25,000 ಅಲ್ಲೇ ಇದೆಯಲ್ಲ. Wait. Adರಲ್ಲಿ they have discharged their liability by examining that RW1. The insurance company has discharged their liability and proved that driver of the offending vehicle is not having valid and effective driving license. In view of judgment of Apex Court, in case of Swan Singh and Poppo, even in respect of third parties, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. Even in case of appeal filed by that owner, the pay and recovery can be ordered as per the judgment of this court in NFA 6334 of 2014, disposed of 1st August 2022. Accordingly, the insurance company is directed to deposit compensation amount and interest. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit balance compensation amount after deducting the amount deposited by the owner appellant and deposit remaining compensation amount, if any, before the tribunal, if any. Amount in deposit is transferred to the tribunal. ಅಲ್ಲ ಅವನ್ ಟ್ರೈ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ ಬಿಡಿ. ಅವನು ನಾಟ್ ಟ್ರೈನಿಂಗ್, ಇಂಟ್ರೆಸ್ಟ್ ಇರುತ್ತೆ. ಎಸ್ ಅಲ್ಲ, remaining amount has to be deposited if any with liberty to recover from the owner of the object. Yes. Next week. Next Wednesday. 64. Yes, what you want? Next week. Next week. Yes.
What up, sir? Court of sir?
Sir, ಹೇಳಿ.
Serial number 27 ಏನಾಯ್ತು? ನಾನು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೆ.
ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ಈಗ ವೆಡ್ನೆಸ್ಡೇಗೆ ಅಂತ ಹೋಗಿದೆ ಸರ್. ಈಗ
ಓಕೆ.
Court officer? Court officer? Hello? Huh.
Section part 180.
Faster.
Serial number 68, I pray for time, may kindly be taken up after vacation.
68?
8.
Yes. At the request of council for respondent number 1, release this matter first week of January.
Much of
Yes. 68, he wants time, Mr. Gurudev Prasad. Suresh. Yes.
much obliged.
Pass over matter number 2, serial number 2, Devi Shama Prasad for appellant, Arini Shivananda.
Dora.
Yes. Week's time is granted to do the needful.
Serial number 3, Shantaraj for appellant, Mrs. Sitaram Rao.
Where is he? Sitaram Rao. Is there any dispute? Then we will have it on Tuesday. Yes. None appear for the respondent. Release this matter on Tuesday.
Shantaraj for appellant, A.M. Venkatesh.
Dispute ಏನು ಇಲ್ಲ. Yes, what is this? ಎಷ್ಟಾಗಿದ್ದಾರ? Where is that discussion? Valid 19% combining so and so. $90% ತಾಂಡಿದಾರ? Yes. Income ಎಷ್ಟು ತಾಂಡಿದಾರ? What is the date of the accident? 15. ಅಂದ್ರೆ 9,000. How? This mental attendance charge was pain and suffering. How many injuries are there? Loss of earning zones, or loss of earning during zones. Really the injuries. Fracture of medical expense, future medical expenses. Of 18 years. Yes. Fracture has been painted so and so, considering monthly stability. Signally, prisoner was working period of 4 months. Later period ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 4 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ? 4 months. Loss of immunities has been announced. Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Future medical expenses ಏನು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? Yes, interest 7%. Yes. Shri Shantraj K. Learned Council appearing for notice to R1 is Learned Council for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed at the risk of the appellant. Shantraj K. Learned Council appearing for claimant has contended that at the time of the accident, he was earning 15,000 per month. The tribunal has assessed notional income of the claimant as 7,000 per month is on lawyer side. It further contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lawyer side. The compensation awarded by the tribunal, future medical expenses is also on lawyer side. Hence, he sought for enhancement of compensation. Is it discussed? What is his age? He further contended that at the time of the accident, he was aged about 18 years. Due to the disability assessed by the doctor, it will affect his marriage prospects. Tribunal has not granted any compensation under that head. that they have grant. Yes. Hence, it contended ANC sought for extension of the enhancement of compensation. For contra, Shri A.M. Venkatesh, Learned Counsel appearing for the insurance company, has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,000 per month. Further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, and future medical expenses, and other on the other hand, the compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 7% is on a higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Counsel for the parties, Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 14/11/2015 due to rash and negligent driving of driver of the car bearing registration number KA41 P6117. Due to that accident, claimant has suffered the following injuries. Have you extracted injuries here, Mr. Shantraj? Which paragraph? Yes.
Open fracture of right leg, both.
Yes, he has suffered following injury at the next second. Open fracture of right leg, both bones. Considering that injury suffered by the claimant and considering that evidence of doctor, the tribunal has rightly assessed whole body disabilities 19%. Next. Even though claimant has claimed that he was earning 500 per day, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2015, the notional income has to be considered as 9,000. At the time of the accident, he was aged about 18 years. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of immunities from 10,000 to 40,000. Loss of income during the later period has to be granted for 4 months. In respect of future medical expenses, due to that accident, claimant has suffered aforesaid injury. Considering the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for future medical expenses from 5,000 to 10,000. At the time of the accident, claimant was aged about 18 years. He has suffered previous injury. Doctor has assessed the disability 19%. Yes, 55% to that limb, 19% to that whole body. Considering that disability suffered by the claimant, it will affect his marriage prospects. Accordingly, 25,000 rupees has been awarded under the head of marriage prospects. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Yes. Where is that Prakash SC? Memo for dispensation of 1 and 2 is dispensed. Yes, we'll dispense it. Next it will come after vacation. Huh? Then we will call for records. Huh. Allah, criminal entire negligence on you only. You are not challenged. Where is he? He is not there. Post this matter first week of January.
Serial number 65, Munyappa D. Naveen for appellant, R. Prakash. Serial number 65.
None appear. Release this matter first week of January.
Serial number 70, within Keshav Prashant for appellant, K.T. Gurdeva Prasad.
Yes, Keshav Prashant. What is this matter, Mr.
Sorry, Malan. Serial number 67 ಇತ್ತು ನಂದು ಎಂತ ಆಯ್ತು ಗೊತ್ತಾಗಲಿಲ್ಲ.
ಬೆಳಗ್ಗೆ 2 weeks ತಗೊಂಡಿದ್ದಾರೆ ಸರ್ ರಮೇಶ್ ಬೆಣ್ಣಿ ಅವರು.
Ravish Benny is some problem today. Yes. What is this? Huh? Where is that?
Keshav Prashant is on leg in Kota number 13, my lord. 13 continue argument ಮಾಡ್ತಾ ಇದೆ.
Yes, but till then let him argue. Let us see. 20. Yes. ಏನಿದು ಜಡ್ಮೆಂಟ್?
Yeah, answer issued by the.
It's a transport vehicle. Package policy loader is covered under the statutes itself. Collected for cleaner, conductor and driver. ಅದರಲ್ಲಿ ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಕಂಡಕ್ಟರ್ ಕ್ಲೀನರ್ ಕವರ್ ಇಲ್ವಾ ಸ್ಟ್ಯಾಟ್ಯೂಟರಿ ಲಯಬಿಲಿಟಿಲಿ? But why they have collected extra 50? ಅಲ್ಲ ಇದು 50 rupees ಕಲೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ, they said liability for driver, conductor and cleaner 50 rupees. ಅದೇ why they have collected extra? PA coverage to owner driver 100. ಆಮೇಲೆ ಲೀಗಲ್ ಲೈಬಿಲಿಟಿ ಟು ಪೇ ಡ್ರೈವರ್, ಕಂಡಕ್ಟರ್ ಅಂಡ್ ಕ್ಲೀನರ್ 50 ಮತ್ತೆ. Yes. Yes, where is he? He has not come. ಎಷ್ಟಾಗಿದೆ? Only that interest has to be reduced 6%. Their contention is only that he is not a loader. That holding that shown so that tribunal properly upset the evidence and commit the tribunal are error holding the appellant hearing live to pay the compensation. The documents available claimant is a businessman. The police document clearly demonstrates same and further claimant has that he is a businessman. It's clear that even then, their case is that you are traveling as an owner of the goods. That is also covered. You are their contention is that the examination he is a businessman. Date of accident he was traveling in this insured goods vehicle. Flower is there. Then that is what that in the ground they have taken in that appeal. Paraground 7 ali. As per the document, claimant was a businessman. Police document demonstrates further claimant has categorically admitted in cross-examination that he is a businessman. Hence, it is clear that on the date of the accident, he was traveling as an insured goods vehicle as a gratuitous passenger. Yes, liability is covered. Wouldn't come with then the BPL available for driver of a said vehicle through the same crash and negligent manner. ವಿತ್ ಅವ್ರು ಯಾರು? ವೆಂಕಟರಾಮಪ್ಪ. ಇವನು ಕೀರ್ತಿ. Yes. No, they said that he is traveling a businessman as a paid passenger antavru. He is neither belongs to that owner of the goods nor a loader. He is traveling as a paid passenger. That may be their contention. But yes, Mr. Keshav Prashant.
My lord, I am in the middle of the argument in other court, but maybe even half an hour time, my lord. We'll come back, my lord. I'm ready for the argument, my lord. Just I'm going on.
There is no other matter. I'm waiting. Yes.
ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. ಬಿಟ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ.
As if it is finished before 10 minutes, you can come back.
I think it may not be possible in 10 minutes. Question of law is arguing in this matter is continuing.
Tuesday. Call this matter on Tuesday, Mr.
ನಾಳೆನೂ ಹಾಕೊಂಡು ನನಗೆ
No, ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಬೆಂಚ್ ಇದೆ. Tuesday.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. Please. I'm sorry, my lord. I'm sorry for this.
No, that all other matters as urgent. I thought that one or two matters can dispose of.
ಇಲ್ಲ, ನಾನು ಮೊನ್ನೆನೂ actually I have taken the adjournment in this case, but somehow I was in the middle of the argument.
Yes, Tuesday.
Please